Hello class, my name is Paul Floyd and this is a module on torts. Torts is defined as civil wrong, and about a third of all business issues and lawyers spending their time on legal issues involves torts, civil wrongs. It's not criminal, it's civil. In the criminal system has sanctions, fines, and imprisonment or carceration. On the civil side, we don't incarcerate people and we don't really do fines. What we do is we allow money damages, which is money paid, or we allow injunctive relief, specific performance, or some type of action that you're asking the court to either mandate happen or prohibit, stop from happening. But generally in the area of torts, we're dealing with money damages. Torts breaks down into three areas: intentional torts, negligence, and strict liability. Insurance covers negligence. Insurance also covers strict liability because the company takes out insurance for that type of dangerous behavior, dangerous activity in the marketplace. But insurance does not cover intentional torts. An intentional tort is an act that you do, or a person does, that is intentional in the behavior. You don't necessarily have to intend to harm, but you must intend to do the act, as we'll see. And there are about 8 or 9 different categories. In the handout that I have, or the PowerPoint, we will go through the intentional torts. But before we get there, let's talk first about strict liability, and then we'll talk briefly about negligence, and then we'll talk about intentional torts. Strict liability, examples of that type of tort would be a zoo animal where a tiger, a bear, a wolf gets out of its cage and then attacks a person and the person's injured. Or the person's running from the tiger and falls and slips and falls and hurts their knee. They would have a claim saying that, well, the tiger, wolf, or lion was dangerous, an abnormally dangerous animal, and the zoo should have insurance for that. So we all pay a little bit more of a price of admission to cover insurance so that if someone is injured from a dangerous animal at the zoo has resources to be able to cover that and pay money damages. Hopefully it doesn't happen, but it's built into the price of the product. Other examples of strict liability are guns, drugs, TNT, dynamite. When you use dynamite to make a road, it's dangerous. When you shoot a gun, it's dangerous. When you have a drug, it may cause harm. And so when you're dealing with strict liability and abnormally dangerous activities, in each of those instances, the manufacturer adds to the cost of the product that you and I ultimately pay for 1 cent, 2 cents, 5 cents, 10 cents to cover insurance so that if it's manufactured, the gun, or if the dynamite was manufactured or handled in an incorrect way, not by the user, but by the manufacturer, then there would be coverage and insurance would cover it. It's liability on the manufacturer without fault. The person who's been harmed does not have to prove it was the manufacturer's fault. It's strict liability. And products liability generally falls under strict liability, although a claim for products liability, as we'll see in a separate portion for this module, would also allow a claim for negligence. Let's move now to the large area called negligence, which insurance does cover. There are 4 elements to a negligent claim: duty, breach, causation, and damages. The duty is a duty that everyone owes, a standard reasonable duty of care. What's the standard of care? A reasonable duty of care in light of the circumstances. Duties are decided by courts, not by juries. Whether you have a duty or not is a legal matter, but once you have a duty or you undertake a duty, you must do so reasonably. So let's say that you're at a convention and you walk into a big room for a meeting. It's a big educational conference and you slip and fall on the cord on the floor and you hurt your knee. The cord was not taped down. You didn't see it. There weren't signs. It was not obvious. You slipped, you hurt your knee. Do you have a claim for negligence? We'd have to first look at, is there a duty? Did the convention center owe you a duty to make sure that when it put cables down, that the cables were reasonably flat to the floor. Is there a way to do that? Yes, you buy tape. A little bit of tape on the floor, not a lot of money, will result in safety. Therefore, a little bit could have been paid or expended for saving somebody's knee. The damage to a knee or to a person falling over is greater than the cost of the tape. And the convention center can, of course, always add a little bit of cost to the room rental to cover the tape or those kind of activities that make the room more safe. So did the convention center owe a duty of care? Yes, they do. Is it a reasonable duty? That's ultimately decided by either an expert, but most of us can do this one on our own. We don't need an expert. Or ultimately it's the jury that decides that. And so a jury sitting in a room goes, well, I've been at convention centers before, and they always tape down those cords. I don't know why they didn't tape it down this time. You know, they're responsible. They have a duty to make sure that their space is safe. They breached that duty. That's the second element, breach. They breached that duty. They did not adhere to it. They did not follow that duty. Why they didn't do so is not relevant. They owed a duty. They breached that duty. It could have been an employee who forgot. Could have been someone that didn't even know. That duty is there on the convention center. It needs to train its staff to put the tape down, and so the cord isn't there to trip over. So there was a duty and there was a breach. Next element we must prove if we're going to win in this kind of a case is that there's causation, cause and effect. But there's two parts to causation in negligence. One is what's called legal or factual causation. But for not putting the tape on the cord, I wouldn't have fallen. But for the cord on the floor not being taped, I fell. So the but for allows you to see in time, but for their behavior and not following the standard of care, I would not have been injured. That's the first element of causation. But as with so many things in the law, there's two parts to causation. Two prongs, we say. The first prong is fact, but for, and the second prong is called proximate cause. Now, as with many legal items and terms, that's a technical legal concept. It means proximate cause does not mean it's within a proximity of. It means that the court, the law, has looked at that kind of behavior and said, yes, we will allow a redress for that type of behavior. Yes, there's a but-for causation, and we will allow that convention center to be held liable because in time and legally they are close to the event. But for getting on the bus that morning and going to the convention center, there wouldn't have been damage to the knee. So can you sue the bus company? And but for being on the train before you got on the bus, can you sue but for? But for goes back in time. But for a fight you had last night, you wouldn't have gotten to work late, which means you wouldn't have gotten on the bus late, which means you wouldn't come to the convention center late, and you wouldn't have been rushing to get to your seat. No, but for cuts off when the court looks at proximate cause. And you sue parties who, in fact, are closely related legally and factually to the duty and the breach. So in this case, yep, duty of care, breach, didn't follow and tape down the cord. 3, causation, but for, yes, proximate cause, convention center fits into that category. And then finally, damages. That's the fourth element of every negligent claim, damages. What are the damages? Well, medical. Had to lose some wages, you weren't able to work, you had a little rehab you had to do, you had to see a psychologist because you're scared to go back into a convention center. Both physical and mental and emotional and psychological damages may or may not be allowed depending upon the harm, the duty that's owed, the party that owes the duty, and the law in the state in which you reside. Torts is a common law claim. It may be codified into statutes, but it has grown out of historically the court saying you have a right to a remedy. Insurance covers negligence, and so most of us have one way or another taken out insurance. So if someone slips and falls in my law office here, there would be coverage. I have insurance to cover that. Why? I probably had some water out front, didn't know it, maybe I came in on a snowy day, person slips and falls. Is it my fault? Well, I have a duty to make sure that the space you enter is safe. It doesn't have water. If you slip and fall on the water, then in fact, I breached a duty. Arguably, but for coming to my office, you wouldn't have had that injury. I'm in the business of allowing my public space to be open, so the court would say, but for facts, yes, causation, and then proximate cause, yes, Paul is one of those in the business, and so the business should be held liable. And then damages would be any medical expenses, maybe a walker, maybe having to have a special therapist, physical therapist, and then other damages that might rise from the injury, lost wages, pain and suffering, etc. When it comes to doctors, lawyers, architects, accountants, veterinarians, professionals, we are held to a heightened standard in negligence. We're not just a reasonable standard of care. We owe a reasonable standard of care to the professional level that we hold ourselves out or that we're trained to. So a neurosurgeon's held to the level of a neurosurgeon, not a general practitioner. But a general practitioner is not held to the standard of a neurosurgeon. So physicians can have different levels, a heightened standard, we say. Architects have a heightened standard. You want the building not to fall. Accountants, you want to make sure that your taxes get paid and they're done right. So every profession has a heightened standard, a higher standard of care. That's the duty owed by the professional. And now we come to the last category, and that's intentional torts. Intentional torts is not an intending to do harm. It's not that you intended to harm someone. The question to always ask is, did the defendant, the party who's being sued, did that party intend to do the act? If the answer is yes, then you've covered your first element, intend to do the act. Second one is, did that party do the act or the behavior? Yes. Did that act or behavior cause the damages to the plaintiff, the victim, the person who was harmed? Has to be yes. And then finally, what are those damages? So you have four elements. Intended to do the act, not intended to do the harm. Did the act cause the injury? What are their damages? And once you've got those elements established, then you have a claim for intentional torts. In the handout, there are 8 or 9 different types of intentional torts that are covered in the book. The textbooks cover each of these, and you can go on the web and do a legal search under legal dictionary, under other legal sources, and you will see these definitions. The first one is an assault, and that is not intending to touch the person, but it's intending to do an act that the victim, the person who was harmed, understood or reasonably perceived to be dangerous. Great bodily harm. GBH, great bodily harm. The person thought, emotionally saw that they were in great bodily harm even though they weren't touched. If so, that's an assault. One other comment about assault and battery, which we're going to get to in B. These are not the same as in the context of a criminal act. The standards are not necessarily the same, and they differ with each state. Some states require other elements for each of these claims, but you look from state to state and there's a general trend. Assault is not the intent to do harm, but the action that resulted in the plaintiff perceiving reasonably great bodily harm. So let's say I have a baseball bat and I'm really angry. I just struck out. It's the World Series. I take the baseball bat. I go back into the room, the dugout, the clubhouse, and I start smashing things up. And in the process, I smash a table, and there's a person who's sitting over there just scared as can be, thinking I'm going to come after him. And therefore, he stands up, slips and falls, hurts his knee. Does he have a claim? Well, as long as he thought that he was in the zone of danger and there was going to be great bodily harm and I was coming after him, even if I never intended and it was a joke or it was just me letting off steam, I'm responsible for my behavior. So that's an assault. A battery is unconsented touching. Best example is you go see the doctor and the doctor says, I'd like to work on your knee. And you say, okay, fine. And he says, may I touch your knee? And you say, sure, you can touch my knee. That's consented touching. What happens if you're a therapist and all of a sudden the therapist hugs you and you didn't ask to be hugged and you have a phobia about being hugged? You'd have a claim against your therapist because for battery, unconsented touching. The next one is fraud. Fraud is a claim that is essentially one where a misstatement of fact is made and it's material. Somebody either intends to deceive or reasonably knew or should have known what they just said is not true. And it has to be not true at the time they said it. So I say to you, I'd like to borrow $10,000. You say, sure. You say, Paul, can you repay it? I go, I got a job. Don't worry. I'll repay your loan. Then 6 days later, I lose my job. You call me up and say, Paul, can you make that payment? I say, I lost my job. You say, well, you defrauded me. You deceived me. No, I didn't. At the time we made the deal, the time we made the contract, the time we had that behavior, I had every intention and had every right, and I had every ability to pay you. Now I don't. So it wasn't fraud. Maybe something else, but it's not fraud. You have to intend to deceive or reasonably knew or should have known your statement was not true or omitted material facts at the time it was made, not later. Next is trespass. Trespass is unconsented entering someone's land. And there are justifications. As you'll see in the book, there's justifications for each of these intentional torts. In this case, the justification would be, I had to. The storm was coming. I had to enter your land. I know it's posted. No hunting. Do not enter my land. But a storm is here. And it's a hurricane or a tornado. I needed to get in your land, and I had to get into a ditch on your land. I can only be on that land for a reasonable period of time. Then I have to leave. So there's justification. Otherwise, with a posted sign, you're trespassing unconsented entrance on someone else's land, and you've entered their land without their authority. That would be called a trespass. You can have a false imprisonment. False imprisonment is when you're being held without your consent. Police says stop. You stop. That's stop and frisk criminally. But in this case, it's a false imprisonment. If you could freely move and you say, can I move? And they say no, you may have a claim for false imprisonment. Recently, a nurse was being arrested by the police without justification, and the police said you have to draw blood from a person who's in your hospital. She said, I'm not drawing blood because the hospital said you don't have authorization, and without authorization, I'm not drawing this person's blood. The police officer said, I'm arresting you. She said, I didn't do anything wrong. He didn't care. He handcuffed her, put her in a police car, closed the door. That's a false imprisonment. Without authorization, held without her consent, she was able to ultimately, I think, settle for $500,000 or more. Why? It made national news. The police officer lost his job. It's significant because he went way beyond what he was supposed to do. It's false imprisonment. Holding someone without their consent. Shoplifting. If you didn't shoplift and they hold you too long, that would be false imprisonment. Of course, if you ground your son or daughter and they're under the age of 18, that's not false imprisonment. That's parents able to ground their children. But if you tried to ground an adult, saying, listen, you can't leave your room, I'm going to lock you in your room and we'll feed you through the door, that would be false imprisonment. Another intentional tort is intentional infliction of emotional distress. You can look at it in the book. It requires very extreme behavior, shocking the conscience, and some of the examples in the text are interesting. It's a rarely used intentional tort. It's growing in time. It requires that the emotional distress is really great on the part of the plaintiff. The intentional act is outrageous. Anyone knew they shouldn't have done that act. Race car driving and then hitting a baby crossing the street would be an example. The race car drivers drag racing, that's extremely dangerous. Not strict liability, there's no insurance to cover it, but the parties who hit the baby crossing the street and the stroller, they would be liable. Next, defamation. It requires that the statement not be true. If it's a true statement, you can't have defamation. Defamation's broken into libel. And slander. Please keep in mind, libel is written, slander is oral. It is a statement that's not true that harms the reputation of the plaintiff, of the victim, of the person who's been harmed. Their reputation's been harmed. And the text has examples of that. If it's a true statement, you may not be sued for defamation, but you might be sued for invasion of privacy, which is the last intentional tort on our list. Invasion of privacy is actually made up of 4 different types of minor claims. 4 categories, subcategories. 1, if you take someone's likeness, Albert Einstein, and you use Albert Einstein's picture on a bagel or on a bag with a bagel and call it Einstein's bagel, you have to pay his estate for it. You have misappropriated a commercial likeness. That includes voices, that includes caricatures, that includes the actual person themselves or photographs, unless they authorize it, because it's being used for a commercial purpose. Another one that's commonly used is to put the person in a false light, to make the person appear to be something that they're not in a negative sense. Minnesota has not adopted that, and some states are very slow in adopting false light. But we have adopted, and many states are adopting another of the four, and that is invasion of privacy. I have a right for certain information to be kept private. That information needs to be maintained private. I have absolute right to assume that. I go see my doctor. He says, Paul, you have HIV/AIDS. That information is completely confidential. If the doctor was to share that, or the hospital, I could sue. If they did it in a way to try to intentionally breach that, not a negligent breach, but intentional, I could sue for intentional infliction or negligent infliction of emotional distress. I'd have to show that I suffered some kind of physical ailment, that I had manifestations, I twitched, I couldn't sleep, I had nightmares, more than just emotional. I have to show physical, usually, manifestations. Nonetheless, private facts being disclosed can be true, and therefore it would not work for defamation, but it will work for a claim for intentional infliction of emotional distress. So these are the three areas of torts: intentional acts not covered by insurance, intending to do the act, not intending to harm; negligence, covered by insurance, the largest area. Everyone owes a duty of care. Put differently, there are no mistakes. If you commit an act that harms somebody else, you're responsible to not do that. And if you did it and didn't follow the reasonable standard of care, then you owe damages because you breached your duty, so long as the court recognizes that's a type of claim we have. And but for your behavior, they wouldn't have suffered the damages. And then finally, strict liability, insurance that's taken out by companies to cover zoos, wrongful death, dangerous dogs at your neighbor's house, guns, drugs, and products. When you buy a bottle of Coke, you assume that you can open it up without the Coke bottle exploding and getting in your eye or something. So strict liability is one of the three areas of torts.